Vice Chair Cook.
Thank you, Mr. Chairman. So, Dr. Phil, before you became Dr. Phil, can you tell us a little bit more about CSI? I think you've been a little modest so far when you said you've been involved in litigation. I want you to be a little more specific about your background.
As I say, I had kind of three areas of focus: clinical, the medical psychology, and my focus in medical psychology was brain and central nervous system. And then I did a year's postdoctoral fellowship in forensic psychology or psychology in the law. And I was a founder of a company called Courtroom Sciences, Inc. It was the original CSI. Probably should have enforced that.
I think so.
But we had a full-service trial science firm, and we were retained by clients to evaluate cases, and we did strategy for cases. We assisted in jury selection, witness preparation. We often had mirror juries, shadow juries in the courtroom that matched the jury that was in the jury box, and we were able to debrief our jury. So what I'm saying is, if we had 12 jurors in the box and there's 7 women and 5 men, then we had 7 women and 5 men in the gallery that matched them. So if we had a 42-year-old woman with 2 children, a barking dog that was a Baptist with a year of college, then we had a woman out here that was 42 years old with 2 children, barking dog, a year of college that was a Baptist. Because you can't talk to the jury every night, but you can talk to your shadow jury every night, and it gives you insight to that. We mock tried cases many times before they went to actual trial to find out how a jury in a particular venue was likely to view a case, and what was important to them and what was not important to them. The difference was at mock trial, instead of having one jury, we seated 4 or 5 or 6, and they went to independent deliberation rooms, deliberated over the actual jury charge as best we could predict what it was going to be, and all of that was videotaped and then analyzed very carefully to see what their problem-solving strategy was going to be, what was important, what was not important, so we knew what to emphasize and not emphasize, whether this particular expert was effective or the other expert was more effective, what they wanted to hear and not wanted to hear. And we focused on telling the truth effectively and getting the best result we could. And sometimes the answer was, you need to settle.
Sure.
Thank you. And we did criminal cases and civil cases, both.
Well, as a former client from a couple of decades ago, I've seen you in action, and I can attest to your skill set. And just want to say thank you for being involved in this case. Thank you for being willing to be here today and take time out of your busy day now that you're Dr. Phil in a different role than what I knew you as a couple of decades ago. But I think I just wanted everyone to know that background. It's not like it's not the typical person talking to a few jurors. You've done this for decades, correct?
I have.
Okay. And you said you read the record. Did you see discussions about a sexual assault of a child involved in the record?
I saw discussions of the sexual assault early on. It was brought up concerning 3 anal tears in a child, I believe it was. This was early on, and it seemed to me that it was brought up to prejudice the jury, frankly. But then it was dropped out later and was not part of the jury charge. It was not something they were asked to render a finding on. And it was not something that they prosecuted on at all. I felt like it was there because it's if you want to inflame a jury panel, then you can put that into the mix. But then it was completely dropped out. It was not paid off. There was no evidence offered about it. No testimony was given about it. There was nothing in the medicals that were offered about it. It was just put in early, but then it was never paid off later.
Fair to say, if we were to grab 100 people off the street, that probably all 100 of those people would agree that that would prejudice the jury, that they heard that type of testimony prior to going to deliberation.
Well, it certainly would, and but as I say, in opening statement, you're not allowed to argue. You're just you're just going to say we believe the evidence will show, and then the jury is expected to see, well, they made that promise. Let's see whether they bring it or they don't. And then in closing argument, the opposing attorney would be expected to say, they stood up and brought this up. Did they ever show you anything to do that? And with something that inflammatory, there's a real question about whether you even want to bring up that they didn't pay it off, because you're reminding them, and it puts it back into the juror's mind. So do you bring it up again, or do you just leave it there? It's a difficult call. But if you examine the record, you will see that there was never one word of testimony from an expert or otherwise to show that there was any even insinuation. And Dr. Francis Green filled out an affidavit on July 9th of this year, and she basically said in her affidavit that if she was going to render an opinion on what the cause of death was and what she saw, there was certainly no mention of that. She disagreed with the cause of death, and she had a firm opinion that the death was caused by severe undiagnosed viral pneumonia, onset of which occurred at least a week to several weeks before her collapse, that there was a viral interstitial pneumonia complicated by secondary necrotizing bacterial bronchopneumonia several days to a week before the death. Necrotizing meaning that it was actually eating tissue in the lungs. And so as a result of bacterial infection, she became septicemic, resulting in all of this coagulation reflected in lab results, and that it was a combination of drugs suppressing respiration, and this was the phenergan or promethazine in two forms, suppository and cough syrup, and none of this other was mentioned at all anywhere in that.
And I know you're not a medical doctor, and I don't expect that you've memorized everything about this case, but do you recall the cause of death as testified to by the medical examiner?
She reviewed so little about it. She just referenced the triad of symptoms and shaken baby, and I can pull up what she said here.
My understanding, and I've not reviewed the record to the level that you have, but my understanding is that there's a certain designation when it is a shaken baby syndrome case, and it's not. It doesn't say shaken baby syndrome on the cause of death, and so I didn't know if you had that available.
No, I can probably find it for you, and I'll get it for you before I leave.
Okay. If not, we can come back to it. Okay. What about as far as the defense attorney a while ago? You said that you would debate whether or not it was proper to bring the sexual assault back up, and would it also be proper to ask for a mistrial? I mean, based upon inflammatory assertions.
Absolutely, I would think that absent any evidence, any witness, no no evidence whatsoever, I would think you could move for a mistrial, but that's certainly not in the record.
And then as far as if in your opinion, is the relief that, the best relief that could be granted would be by the Court of Criminal Appeals in the form of a new trial? Do you believe that that's the best case scenario?
Well, I certainly think at a minimum, there should be either an evidentiary hearing to show how this man's rights have been violated, and or a new trial, which I think would be pretty clear.
And would the two best pieces of evidence that you know of, would it be the CAT scan of the brain and also the photo that you showed earlier with regard to the child's lungs?
I think that, along with the history of her going into respiratory distress absent him being in her orbit. I mean, he wasn't in her life when this started happening. And listen, if I need to say, I work with the Innocence Project some, and for a number of years, and I've had cases brought to me that I look at, and I've been to death row and interviewed inmates and walked away and said, I'm not
feeling it.
Not feeling it at all. I can't, in good conscience, say that I can get behind this. If I can't study the record and look the individual in the eye and passionately believe that there's been a miscarriage of justice, I just don't step up to them. So I don't get involved with everyone that's presented to me by a long shot.
Sure.
But when I see something like this, you can't walk away.
Well, thank you for being here today, and thank you for your testimony.
Chairman Leach. Thank you.